15. Conclusions. Certain of the foregoing chapters should have made it evident that there has been marked mutability in many fields of law, particularly in those which relate to women and children. To sum up, we now find more regard for woman as a legal personality than in the past, and a greater parity with man in her responsibility for and control of children and property. Also, we find a deeper concern for all members of society, but particularly for children and those who are unable to care for themselves. This is shown in the juvenile court laws and the Social Security legislation. The forces which have produced the changes and progress have come about through three forces. Social and economic conditions of living have brought about a change in the legal problems and a subsequent realignment of the substantive law which relates to the rights of human beings under varying conditions. Changes in the mechanics of trial procedure have brought a simplified process of enforcing these rights, and an open-minded attitude on the part of those in the legal profession has increasingly made the law a satisfactory tool for promoting the welfare of society. This last is illustrated by the activities of the American Bar Association and other legal groups. Progress in the field of criminal law. The field of criminal law procedure illustrates the second point. The attitude toward that particular subject is still one of inflexibility in many respects, as indicated by the lingering adherence to slow and unwieldy procedure with lengthy and verbose indictments. But these have to some extent been simplified. Usually the charge may be set forth by a brief statement of the facts, and it is possible in a large number of states for the prosecution to begin upon an information of the prosecuting officer instead of by means of the indictment of the grand jury. The difference between these two methods is important, for in the first instance the legally trained person is the one who finally determines whether or not a particular person shall be prosecuted, and in the second instance this is decided by the grand jury, which is made up of men who are without training or special knowledge of legal principles. The former way is simpler and more likely to expedite the trial process. Therefore, it is less expensive and is being used in many states in the trial of serious as well as minor crimes. The process of growth has been at work in another way in the trial of cases. For in some states it is possible for a defendant to waive a jury trial and have a hearing before a judge. If this becomes a generally accepted practice, the rules of evidence may become more flexible, as they are already in hearings before various commissions or boards of arbitration which serve in a combined administrative and judicial capacity. In order to avoid a trial, the court sometimes allows a defendant to compromise by pleading guilty to a lesser crime than the one with which he is charged. This is a step toward elimination of the delay which is so many times a part of the legal process, and it may be considered as one form of conciliation. Conciliation. While delay may amount to a postponement of justice, a speedy course is often impossible under the present conditions except through conciliation. By this process, the differences of the parties are settled by mutual and amicable agreement, in place of a battle in court which is fought by the attorneys for their clients and is expensive and time-consuming. The thing that is socially desirable but which cannot be accomplished by strict adherence to legal principles can sometimes be brought about by this practice, for the attorneys can often accomplish the desired result by applying the conference method in settling the client's difficulties. Conciliation is often used in family courts and has been effective in slander suits and even in cases involving disagreements on technical and scientific points. While it saves time and expense and transforms a disagreeable quarrel with its unpleasant aftermath into a friendly compromise, it also requires great skill, tact, and a singular understanding of human beings and their problems. Some legal authorities go so far as to say that an attempt at conciliation should precede every litigation, and the American Bar Association endorses it by using the words of Lincoln as a preface to the canons of ethics of that association. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the loser in fees, expense, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. Legal organizations working for justice. The legal aid societies which exist in our large cities bring help and justice to the clients who cannot afford to pay for legal services. The American Law Institute, an organization originated by some of the greatest legal personalities in the country, has worked since 1923 to promote the clarification and simplification of the law and its better adaptation to social needs, to secure the better administration of justice, and to encourage and carry on scholarly and scientific legal work. One of its contributions has been a code that is recommended for criminal procedure. This provides the mechanics of trial procedure from the arrest through to the sentence and execution, and also the procedure on appeal. This is not a force to combat crime and its causes. Neither does it change the personnel of those administering the law nor bring about the reformation or control of the offender after conviction. In these realms, we are dealing with the unknown forces of the individual personality, the psychological and emotional life of individuals. However, the rather recent interest in prevention, the demand for better police personnel, and in some places the merger of inferior courts, such as police courts, with trial courts so that a single tribunal will be responsible for the whole procedure of examination and trial, show the results of the work done by this body. Interrelationship with allied fields. The American Bar Association, under its criminal law section, has had committees on various subjects, and among the most important are those on medical legal problems and on psychiatric jurisprudence. These committees have worked with committees from the American Medical Association and the American Psychiatric Association in an effort to understand the problems of criminal justice that show a close interrelationship with these allied fields. Along the line of research pertaining to mental disorders, emphasis has been placed on 4 distinct stages. The first operates when a person is a mental defective and is taken into custody and given care for his own protection. The other 3 are effective after a criminal act has been committed, and relate to the condition of the person successively at the time the act was committed, at the time of trial, and, finally, at the time of the disposition of the party. The science of human behavior, or psychiatry, has a bearing on all these points, and as early as 1929 this committee recommended the following. 1. That there be available to every criminal and juvenile court a psychiatric service to assist the court in the disposition of offenders. 2. That no criminal be sentenced for any felony in any case in which the judge has any discretion as to the sentence until there be filed as a part of the record a psychiatric report. 3. That there be a psychiatric service available to every penal and correctional institution. 4. That there be a psychiatric report on every prisoner convicted of a felony before he is released. 5. That there be established in each state a complete system of administrative transfer and parole, and that there be no decision for or against any parole or any transfer from one institution to another without a psychiatric report. Later recommendations included a survey to ascertain the extent of psychiatric service in the courts. The problem of the petty offender who comes into the municipal or the police courts was studied in an effort to improve the methods in these courts by means of psychiatric case work. This would seem to indicate an interest in readjustment and unity within the profession of the law itself. What is the law? The law must be considered as something more than rules of action written down in black and white which are interpreted by the legal profession. It deals not only with legal problems, but also with all the problems of human relationships. It embodies ideals which are not based entirely upon legal precepts, but upon tradition and centuries of living. These ideals form a pattern for life today. We find a group who would like to have the law more definite and exact in its answers. As a problem in mathematics, others complain of the rigidity and lack of creative insight. Both criticisms are partially true, and though the law has a quality of definiteness in some of its terms and procedure, it can never be so fixed that it can settle any controversy that may arise in a way that is wholly predictable. It is this uncertainty that gives it life and fascination, and which made Oliver Wendell Holmes, Jr. write, "When I think of the law I see a princess, mightier than she who once wrought a babe, eternally weaving into her web dim figures of the ever-lengthening past, figures too dim to be noticed by the idle, too symbolic to be interpreted by her pupils, but to the discerning eye disclosing every painful step in every world-shaking contest by which mankind has worked its way from savage isolation to organic social life.